Good morning, everyone. I'm going to give a couple seconds as I see the attendees trickling in. And we'll get started in about 30 seconds to a minute. Looks like we have over half of our attendees chiming in. All right, I'll give it just a few more seconds and then we'll get started. All right, good morning, everyone. My name is Nico. I'm excited to be the headliner for our CGMC summer webinars. We're really excited to have you here. A little bit about me. So I'm a labor and employment attorney with Flaherty and Hood. A lot of my work revolves around labor negotiations, arbitrations, grievances, and advising on unfair labor practices, which is what we'll be talking about today. Now, some of you, or the majority of you, have probably heard me say it a couple times, so I apologize. I'm originally from the Chicago area, and in Illinois, there is no shortage of unfair labor practices. It's in our normal vocabulary when we're talking about labor negotiations. It happens quite a bit. And I'll walk through what it looks like today in another state that has a functioning labor board. All righty. So welcome to More Unfair Labor Practices Claims Against Public Employers Coming Soon. And this isn't meant to scare you, but it's meant to definitely alert you to some big changes happening in Minnesota. Before we dive in, let me just inform you, if you have questions, you can use the Q&A function. And then we'll work on answering them live throughout the presentation. And of course, we'll come back to questions at the end. So what we're going to talk about today, here's our roadmap, is we're going to explain what the heck an unfair labor practice is, why we're talking about it now, and we're going to give you a little bit of background information on the labor law and the labor board, and then we'll give you insight as to what the actual process of filing a ULP and seeing it go through the board looks like. So what is an unfair labor practice? Well, generally, an unfair labor practice is something that refers to an act, whether it's done by an employee, an employer, or a union, and there is a violation as a result of that act in some labor law or regulations. And in Minnesota, the Public Employment Labor Relations Act, PELRA, it decides what constitutes a ULP. And so we'll look at what are some textbook examples of ULPs in Minnesota. And when I say textbook examples, I'm talking about this is the actual language from the statute. So in Minnesota, public employers, their agents, and their representatives are prohibited from, 1, interfering, restraining, or coercing employees in the exercise of rights guaranteed by PELRA. I call this one the catch-all. So if the glove doesn't fit anywhere else, this is what unions and employees might look to see if they can file an unfair labor practice claim. This happens consistently in Illinois, for example. Most of the ULPs, if not a substantial amount, if not a majority, will be pinned to this number 1. Number 2 is dominating or interfering with the formation, existence, or administration of an employee organization. This is a very broad one. So this too is what is pinned to quite a bit. And then there is the perhaps more obvious one, which is discriminating in regard to hire or tenure to encourage or discourage membership in an employee organization. That looks like, I don't want to hire you because you are, union friendly, or you've been historically a member of the union, for example. And that one is a little more overt. So you don't really see ULPs too often clinging to number 3. You'll see them clinging more to the more broad ones, number 1 and 2. Then we have discharging or otherwise discriminating against an employee because they have signed an FI or filed an affidavit, petition, complaint, etc., as part of this process. A very popular one, which is strategically used in labor negotiations in Illinois, and will likely surface here in that same venue, is refusing to meet and negotiate in good faith with the exclusive representative of its employees in an appropriate unit. On its face, right, that looks like we've just decided not to meet with you because we don't want to negotiate. But what this also does is create some sort of duty to negotiate in good faith. And we'll talk through a case example of that later on in today. Then you have refusing to comply with grievance procedures contained in an agreement, distributing or circulating a blacklist of individuals exercising a legal right or of members of a labor organization for the purposes of preventing blacklisted individuals from obtaining or restraining employment. And number 8, violating rules established by the commissioner. Number 9, refusing to comply with the valid decision of a binding arbitration panel or arbitrator. Now, those are all the things that can be brought against employers if they misstep or engage in an unfair labor practice. The law also prohibits certain activity by unions and their members, public employees, representatives. So employee organizations, their agents, the representatives, and public employees are prohibited from restraining or coercing employees in the exercise of rights in PERB, restraining or coercing a public employer in the election of representatives to be employed to meet and negotiate or to adjust grievances, refusing to meet and negotiate in good faith with a public employer if the employee organization is the exclusive representative of employees in an appropriate unit, violating rules established by the commissioner, refusing to comply with a valid arbitration decision, calling, instituting, maintaining, or conducting a strike or boycott against any public employer on account of any jurisdictional controversy, coercing or restraining any person with the effect of force or require any public employer to cease doing business with them, force or require a public employer to recognize for representation purposes an employee organization not certified by the commissioner, refuse to handle goods or perform services, or prevent an employee from providing services to the employer. And then the last ones include committing any act designed to damage or actually damage physical property or endangering the safety of persons while engaging in a strike, forcing or requiring any employer to assign particular work, causing or attempting to cause a public employer to pay or deliver or agree to pay or deliver any money or other thing of value in the nature of exaction for services which are not performed or not to be performed, and engaging in an unlawful strike. The last ones, I'm just going to rattle off. Picketing, which has an unlawful purpose, such as a secondary boycott. Picketing, which unreasonably interferes with the ingress and egress to facilities. Seizing or occupying or destroying property, violating or refusing to comply with a lawful order of the commissioner or board. So as you can see from all of these, there are a lot of prohibitions as to what a union or its members can do in the workplace as well. It's not one-sided. So where does all this come from? It comes from the Public Labor Relations Act. And who is the enforcer? Well, it's gone back and forth over the decades. And it wasn't really until recently that some power was given to what is called the Public Employment Relations Board. And That is because Minnesota has a history of forcing these claims to go through district court. Well, now the law was changed, and the board will have authority and money to oversee these claims. I'll talk a little bit more about what that looks like. So what happens though if you get an unfair labor practice? What's some of the liability that you might see? So any party, they can get injunctive relief, aka they can say stop doing that. The court can order that, or they can get damages. So they were harmed in some way in that manifested in money damages, for example, and they'd have to show that that was caused by an unfair labor practice. And then whenever it appears that a party has violated a final order of the board must petition the district court for an order directing the party to comply with the order of the board. The court may grant or refuse, or in whole or in part, the relief sought, provided that the court also may stay an order of the board pending disposition of the proceedings. In essence, the most important part of this provision that comes from PELRA is that the court may punish a violation of its order as civil contempt. So the court may hold someone in civil contempt. And the board itself has power under the law to, once a complaint has been filed with them, so I'll go over this more in the process, but there's in essence 2 separate instruments that get you into the PERB process. There's a charge, which is the first part, and I'll walk through what that looks like. Then there is a complaint, and that's if your charge doesn't get dismissed. So if you get to the complaint part, then the board has power to has some power such as a temporary relief or a restraining order. So why are we talking about all this now? Why am I headlining the summer webinars? Well, as you now know, a law was passed that starting July 1st, the board will, one, have money. So they're going to get $750,000 appropriated to them this year. And 2, the law that took away their jurisdiction is sunsetting. It's ending as of June, end of day, June 30th. So starting July 1st, the PERB has jurisdiction again, and they have money in their pocket. So that's why we're talking about this right now. And what does this mean for you? Well, as I've alluded to, well, first, right, they're going to have money. The law takes away the jurisdiction. But what this practically means is that it will be easier, quicker, and a lot cheaper to go the PERB route than it has historically been to go through district court. So to go to the board, right, there's essentially de minimis costs that come with that. Going to court, right off the bat, that includes filing fees. So there's generally no cost except for hearing transcripts and some other de minimis cost. So what this means is more individuals are likely going to take advantage of this route, especially unions who have, a lot of them have been leveraging the grievance processes this year. They might take a grievance and go through that should have gone through a process like this, more likely so, and go through the board process. And this comes as well as ULPs are on the rise. So over the past few years, there has been a decline in unfair labor practice charges filed within the private sector with the National Labor Relations Board. That has been changing, and the amount of cases have been increasing. So just in 2022, there was a jump. There have been a good amount of cases filed this year as well, and I'll let you know just how many were filed in the jurisdiction that the state of Minnesota is part of, and particularly just the state in one single month. So I alluded to it a little bit earlier, but what does this mean in terms of how are things going to change in your day-to-day practice when it comes to labor relations? Well, ULPs, because it is more practically accessible, cheaper, and quicker, they might be you might see them used as leverage more often when you're in the middle of labor negotiations or grievances, because the the person on the other side might not be bluffing, because the process, right, is easier to go through. So what this means is you might hear that, more talk about whether or not you're bargaining in good faith. You might hear more, claims as to whether something is an unfair labor practice. So it's going to be used as leverage. And at the same time, right, they might try to take two bites at the apple on the same issue. They might also file a grievance. This doesn't necessarily mean they won't file a grievance, but now they have another viable route, again, that is accessible, cheap, and quicker than government. So they might continue through grievances and throw in a claim or charge to the board. A lot of charges, as I alluded to, are refusing to meet and negotiate in good faith. That is often what it comes in the form of, whether when you're negotiating about something and the union says, well, we don't think that this is good faith. And that could be something as simple as taking too long to schedule a follow-up meeting. It could be a numerous amount of issues, and that is because the provision is very broad. So, all right, gave you all the textbook stuff. Let's look at what PELRA is in Minnesota, how it came to be a little bit, and what the board, the history of the board and how it came to be, and what's the current makeup of it. So the Public Employment Labor Relations Act was enacted in 1971. So it's been around for a good amount of time, and with the original purpose being to grant public employees the right to organize, bargain collectively, subject, however, to the paramount rights of the citizens of this state to keep inviolate the guarantees of their health, education, safety, and welfare. So 1971, that's when PELRA is enacted. We see that a form of the PERB, the board, was created back in 1984. Well, what originally was created back in 1984 more so resembles the Bureau of Mediation Services today. So even back to 1989, the ULPs, they were going through district court. They were going through district court in 1992, and technically the board, PERB, was eliminated and BMS was formally prescribed into the law. And a lot of the duties that the board had under the existing law at the time were shifted over to BMS. So throughout this time, claims are going through district court. Fast forward to 2014, PERB gets a new look. They're reborn with the purpose of considering these charges, adjudicating them, and the provision that says you must go through district court is at that stricken. Well, we kind of know what happened, right? Because it's been silent still for many years since 2014, they didn't get that much money. And because of that, they were substantially limited in the amount of cases that they could take on. At the time, they were given an appropriation annually of $125,000. And in 2021, that they were given a last appropriation amount of $125,000. And that was more so to finish up the cases that they had. They lost jurisdiction over new cases, and any new cases until the law sunset, at least on June 30, 2023, any new cases would have to go through district court. Well, we know what happened now. PERB got $750,000, which is more than it has historically. and the 2021 law sunset, and jurisdiction is reverting back to the board to oversee these charges and complaints, much like the board does in other, similar states with similar laws. So what does the board look like? There are 3 members. One is a representative of the employer, one is the representative of the employee, one is at large, and in concept is supposed to be a public representative or a neutral representative, as they refer to it on their website. And what happens is the board selects one of its members to serve as chair at the beginning of July 1st. So we don't know who is going to be the chair yet. And what we do know is who is the employer representative. We have a Martin Munich, who is a senior assistant county attorney, labor and employment with Hennepin County Attorney's Office. And then on the an alternate for Martin would be Scott Lepick, who is a shareholder and attorney at Barnett, Guzzi, and Steffen. And then we have individuals on the employee side. So we have Margaret and Richard, and both of them work for unions. One is an attorney and one is a benefits and equity rep. And then on the public side, both of them are listed as alternates right now because the board hasn't also picked who will fulfill that public representative role. So we have a professor of law on the roster and an arbitrator and actually a former NLRB regional director. All right, so what's the process? Holistically, with an unfair labor practice, what you do is you fill out a form, you file it, and you serve it. And then there's typically an investigation period that involves evidence gathering. Then there may be a mediation if it's required. Then there may be an informal conference, and also an opportunity to withdraw such charge is given. And after all this, it's decided whether or not the charge will be dismissed or it will proceed through a complaint. If you get the green light to go for a complaint, then you go to the hearing and decision process. So the form filed serve, it's pretty straightforward. You file a written charge or a charge in a form that's already created by PERB. You provide your position statement, and the charge is submitted. You can do it online or in person, and a complete copy of it must be given to each party that is named, and then a case number is assigned. As part of the evidence gathering section, each charging party must submit evidence within 7 days of the date is filed. The charged party is allowed time to respond then 14 days from the date the charge is served on them. Both of which may be extended for good cause by the investigator. Sometimes the board or its designee will require a mediation, and that would look similar to going through BMS for a mediator. And that doesn't necessarily dismiss anything in itself. That's why it's more seen as like a timeout. So the investigation's on pause while you're in mediation to see if settlement is going to happen. It gives another opportunity for a bite at the apple at getting the issue resolved in favor of the charging party. Then there are informal conferences, which are not so much the same as mediation, but pretty similar. It's another opportunity to discuss settlement. And after that, if the charge is found to have no reasonable basis in law, the charging party has the opportunity to withdraw before such a decision is made against them. Otherwise, the decision to dismiss would be made against them. So when you get to the end of the charge process, If there is no reasonable basis in law, then you're going to see dismissal. If there is a reasonable basis, then what will happen is a complaint will be served by the board, and that will entail a more court-looking legal process. That ultimately results in a hearing. So when we look to the hearing process includes the opportunity to answer a complaint within 7 days after service of the complaint or amended complaint. Prior to the hearing, there are pre-hearing conferences. So for those who have had some duty disability cases, this will have some similarity to that, in which may include information such as a position statement, list of witnesses, nature of their testimony, and other information that the hearing officers may deem necessary. The hearing addresses the issues that are alleged in the complaint. In the hearing, testimony may be given, which is where a party may present evidence and witnesses. Again, for those who have worked with us on duty disability cases, this would look similar to that. Rebuttal testimony, and argument on the issues, and an opportunity to cross-examine such witnesses. So it resembles very much so a trial. All of this is done with a hearing officer, and the hearing officer has the following duties. They regulate the proceedings, they receive testimony and evidence, they rule on request for continuances, they rule on motions to sequester witnesses, which is saying you can't be in the room, you can't hear everything that's being said. Issue subpoenas and rules upon motions to revoke subpoenas. They rule on objections, motions, and questions of procedure, authorize the submission of briefs and set time for their filing, and they hear closing arguments and render and serve the recommended decision in order to the board and the parties to the proceeding. So that is an overview, pretty detailed overview of what the process looks like if you file a charge and if you go through the complaint process through the board. So through all of this, there may be a concern with data. And we talk a lot about protecting data under the Minnesota Government Data Practices Act. What happens here is, so all data is maintained by PERB about a charge of unfair labor practices. Those are classified as protected non-public or confidential data prior to being admitted into evidence at a hearing. So data that are admitted into evidence at a hearing are public unless subject to a protective order as the board or the hearing officer determines. Statements by individuals that are provided to the board are private data on individuals prior to being admitted into evidence at a hearing and become public once admitted into evidence. Most other data is considered public. And then there's one more caveat. The open meeting law does not apply to the board when they're hearing cases on its merits. So as you may have guessed, there have not been very many unfair labor practices in the state of Minnesota. Alone from 2018 to 2022, there have only been 16 unfair labor practices filed in Minnesota. That is in comparison to, for example, Illinois, which in the same amount of time, roughly, had a total of 167 unfair labor practices. In 2018 to 2019, there were 56 board decisions ordered. 2019 to 2020, 29 board. 2020 to 2021, 48. 2021 to 2022, 34. So let's put this a little bit into perspective, however. Illinois has roughly 12.67 million people, which is a little more than double Minnesota's 5.7 million. So if we really ballpark it, Minnesota could see around half of the Illinois cases once PERB is fully up and running. And an estimate when the PERB is really up and running is an approximate of 30 hearings, not just charges, per year. So 4 times the average amount of charges in the last 6 years. Each hearing costs approximately $8,000, and the majority is for of the hearing cost. Is the hearing cost. And then let's peek at the private sector to understand where the trends are going in the private sector as it comes to labor charges. So in Minnesota, its private sector in the month of May alone saw 35 charges filed with the National Labor Relations Board. 35 in the month of May alone. This is a system that is modeling, or should I say, PERB is modeled after the system that the National Labor Relations Board has. So as we see, once a fully functioning, accessible organization is established and has money and jurisdiction, they have more charges. Now, one caveat I'll make is that the private sector does have a larger amount of employees, so a larger employee population. So I just want to make that note. But that's why I only looked at it in the month of May, just to give you an idea of where the trends are heading. And real briefly, I want to touch on some of the big cases in Minnesota regarding unfair labor practices. So you see here, the Minnesota Supreme Court issued in its Foley Education Association versus Independent School District, it issued a test that determines when a unilateral change of a term or condition of employment constitutes an unfair labor practice. And this is relevant because this is one that unions will often pin their charge to, saying that there was a unilateral change in terms of conditions of employment. Therefore, you didn't bargain in good faith, or you bargained in bad faith, the inverse of that, an implied requirement to not bargain in bad faith. So we look to this. The analysis that's set forth, or the test that's set forth by Foley, can be summarized into 3 questions. Does the unilateral change involve a mandatory subject? If not, then it's not a per se unfair labor practice. It may not be an unfair labor practice. Is the unilateral change consistent with a past practice? Then it's not a true unilateral change under this test, under this court decision, because it's been occurring in the past. So if it's rooted in that, then it's not per se ULP. And even if the above 1 and number 2 answers are not favorable to the employer, did the employer refuse to bargain? If no, then you may have some defense. Some other cases that clarified some components of the law include retaliatory discharges. Those are considered in violation of subdivision 2.4 of PELRA and constitute an unfair labor practice. A change consistent with past practice is not an unfair labor practice. And so this was also quoted in another decision, because the practices, and here's the reasoning, are equally a part of the collective bargaining agreement, although not expressed in it. So let's look at some examples in other states. In Illinois, as I alluded to, a lot of the charges surround whether or not an employer is bargaining in good faith. And let me caveat with that with the same could be said about the other side, right? There's a requirement for both to bargain in good faith, not just one, but you often see it manifesting against an employer. And here's one example from Illinois. So North Riverside firefighters versus North Riverside. In North Riverside, the decision, the board held that the village violated the provision talking about bargaining in good faith by failing to maintain the status quo while interest arbitration proceedings were pending. So they're in the midst of arbitration, and they receive a charge for an unfair labor practice because they decided to implement changes that are different from the status quo. And Because of that, it was found that they had violated the provision that talks about the requirement to bargain in good faith. Now, again, let me remind you that this goes both ways. There is a requirement to bargain in good faith on both sides. And in the event that someone is not coming to the table and bargaining in good faith, a charge similarly can be lodged against that violating party. It's not just the employer. But the reason I wanted to point this out is because the provision in Illinois' public labor law that talks about the requirement to bargain in good faith is substantially similar to Minnesota's PELRA. So if you look at section 10A4 of the Illinois public labor law, the language is going to be very similar in its requirement for bargaining in good faith to Minnesota subdivision 2.4. Another example, and I thought this was just an interesting one because employees often confuse the role of their representatives, their unions. And I saw charges like this a lot that were just filed in the wrong venue. Someone was facing discrimination in the workplace, and it was based on race or national origin. And let me caveat that with there was nothing about that in the labor agreement that the person was covered under. And they filed, instead of filing just with the EEOC, they filed a charge with the Illinois Labor Board, saying that they're being discriminated against. And the board took this in a very literal sense. And they evaluated, well, what does it mean to discriminate against a person under our law? So this test doesn't exactly exist in Minnesota, but I thought it would be interesting to look at a test that was created in Illinois under a provision that has substantially similar language to our provisions as well. So in Illinois, under section 10A1, if to discriminate in a union setting, this is what it must look like. So the employee must present some evidence that, one, the employee engaged in union and or protected concerted activity, the employer knew of that activity, the employer took adverse action, discipline, including discharge, demotion, suspension, stuff like that. They took some adverse action, and the employee's protected concerted activity and or union activity was a substantial or motivating factor in the adverse employment action. So there's a requirement to proffer that it was a motivating or a substantial factor in that employment action. So none of this talks about race or national origin because that's simply not what the law covers. So this is an example where the board the executive director first dismissed a charge, and that charge came from the named individual, Carmen Rentas, on the basis of race and national origin. It was dismissed because there was no subject matter jurisdiction, but the executive director and the board taking it quite literally, the prima facie case, that's the number 1, 2, 3, and 4 down below, none of that was satisfied. So it was ditched. So what are some practical takeaways from all of this? I think it's clear that from everything I've shared, clear enough that the PERB, the return of it, will likely result in more unfair labor practices. And again, that's because it's easier, cheaper, almost no cost except for transcript copies and other de minimis cost. And it is quicker than to file in court. The dates for turnaround are quicker. The decisions are rendered more quickly. It is overall a faster process, caveated again, compared to court. And the grievance issues that may have crossed your mind, wow, those don't seem grievable. Those may then appear in the form of a ULP because this process is more accessible and easier to do. Why not submit it in an unfair labor practice, especially if on the other side, they have an idea or a notion that, yeah, this may not be an actual grievable issue. So that being said, you will likely see more unfair labor practices. I think it's fair to say you will see more than we have seen in the past, 16 over the course of quite a few years. That is expected to change. And what I would say is, of those list of individuals I showed you on the board, keep an eye out for who is going to be appointed the permanent, neutral, or public member. Because right now there are 2 alternates, and the alternate fills in when the permanent person cannot, fulfill their duties. And it could be as simple as, the person's personal politics or how, their perspective. It's a small board of 3 people, employer, union, and a public neutral. One of them is the chair. So one person makes a big difference. And with that, I'm saying keep an eye out for who is going to be appointed that permanent neutral and who is going to be appointed the chair. And we won't know this until July at least. So what you can do is Google the members and see what the ultimate decision was after they meet for the first time in July. And ultimately, what I want to, a takeaway I'd like to leave you with is that Minnesota will be filling in some blanks. As you saw, tests like this don't currently exist so expressly in Minnesota. There is a lot of ambiguity. And there's a lot of ambiguity because there have not been a lot of issues tested in Minnesota comparatively to other states that have historically had active public labor boards. So when you look at Illinois and you see 167 decisions being made in a time span of, I'll say 5+ years. When you look at Illinois, you see that there is a plethora of law that has been interpreted, but here we just have that we have those gaps. There's a lot of unknown or untested waters, but that doesn't necessarily mean that anyone is remaking the wheel. So we have substantially similar language to the National Labor Relations Act. We have substantially similar language to the surrounding states that have public labor laws. Now, the Supreme Court in Minnesota has said the National Labor Relations Act is merely, or the board, their decisions are merely instructive, because there is a distinct difference in private employment versus public employment. This is not a profit-driven sector, and the issues look different as well in public employment. So with that being said, the board may look only for mere persuasive purposes, look to the National Labor Relations Board, but they might look to states like Illinois, Wisconsin, California, Ohio, even Florida, and see how those boards have come to reason similar cases that have come before them in the past, since we've had uncharted waters. Then one more takeaway, just practically, is, if you're worried about making a misstep, then you'll want to consult your labor attorney, because like I said, this is not a new wheel. We don't want to recreate the wheel. We can look to other states and see what the reasoning was there, and see if the court would, if the language was so similar that the court might entertain a similar argument. And here are some general recommendations. So establish and review for legal compliance written guidelines and policies that address the following with appropriate context and examples. Lines of authority for employment issues. You want to be very clear on who are your representatives, who are the individuals who can make employment issue decisions. Communications with third parties and social media, access to and use of government real property, use of government equipment and technology, conflicts of interest, respectful workplace, data practices, political activity and solicitation. You also want to respond and take appropriate action against employees if reputation, productivity, morale, or ability to provide public service is undermined by employee statements. Recognize when an employee engages in legally protected speech and proceed with caution in responding and taking action. Provide sufficient notice to unions of policy changes, even if certain or uncertain whether negotiable, to gauge their dispute and preserve argument that notice was provided. And clarify and enforce with unions designated employer representatives proper communication channels. And move quickly on responding to ULP charges. So with that being said, I'll now open the floor to questions. Let's take a look and see what's. Okay, we have one question. Would it be considered a ULP if an employer representative complains to the union representative about the employer's decision to offer a higher starting wage to a candidate during job offer negotiations with the candidate for a union position with the employer? This employer representative is good friends with the union representative, so the complaining is done as gossip. Well, let's look at the basics of the text. And I'll give you a general example. I'll speak more generally to that one. So public employers, I'm going to take you to the broad ones, right? Because ULPs are going to fall into certain categories. The basics of the law is public employers are anyone who can be argued successfully to be their agents or representatives. So if you're an agent or representative, you're still covered under this law, are prohibited from interfering, restraining, or coercing employees in the exercise of rights that are guaranteed under this law. That's a big catch-all. Also, discriminating in regard to hire or tenure to encourage or discourage membership. So going back to the heart of the question, right? It asked, would it be considered a ULP if an employer representative complains to the union representative about the employer's decision to offer a higher starting wage to a candidate during job offer negotiations? So if we take that as its essence, right, we want to be mindful of who are designated agents and representatives. Is it likely they'll be successfully argued to be either of those? In essence, they're the public employer. And then are they engaging in any of these? Number one, number two, number three, right? These are the ones that are very popular. And also bargaining in good faith, but this seems more like a hiring issue. So I don't have an easy answer for you that this is for sure an unfair labor practice, and that is because there are untested waters. But right, if you're concerned about an unfair labor practice occurring, then it's likely that the catch-all provision is going to be the one that you'll want to be mindful of. You'll want to think about who the parties are and if the possible claim could fall into that catch-all category. Okay, so then we had some other questions. Moving on to, so one individual had this question. I'm not clear, but is going to PERB a one-way street just for unions to file charges? Is this open for employers for unfair bargaining practices? I'm thinking of negotiating in good faith when we have union members going directly to council members during contract negotiations. Employers can pursue complaints as well. Yep, this is not a one-way street. This will be an accessible and cheaper process for you as well to enforce, to take actions to enforce against unfair labor practices in your workplace as well. Another question is, how do you see the potential interplay between what I understand is now staffing quotas no longer being a management right and the ULP? So the answer is unions can claim bad faith negotiations by changing staffing levels as a ULP now through PERB. How do you see this affecting unrepresented employees? So here's the answer. Unrepresented employees still have rights under PELRA to engage in concerted activity to discuss workplace issues. So they could potentially use this process as they are currently to bring claims, against their workplace. And what this commonly looks like in the private sector is two individuals, or I'll say, two or more individuals are talking about how they don't like their pay, and they get caught about that, and they are, disciplined before that or fired because they were all talking to each other about their pay. So the charge in that situation would be you're interfering with my right to engage in concerted activity, because concerted activity is two or more individuals coming together to talk about, terms and conditions of employment. And in the private sector, a black letter law example of that is talking about your wages. And so employees, whether or not they're represented, have filed claims or charges under the National Labor Relations Board where those instances have occurred. All right. Any other questions? Well, with that being said, thank you very much, everyone, for joining us. I want to share quickly before we depart that we have some upcoming webinars that you can participate in. So we have an upcoming event. We have the Unemployment Insurance Tips and Tactics webinar. That's going to be on June 13th, 10 a.m. to 11:30. And then we have the CGMC Summer Conference, and that will be held July 26th through 28th in Thief River Falls. One more note I wanted to talk about before I let you all go is that after a hearing, if an order is rendered by the board and you don't obey that order, right, the person who is not following that order can be held in civil contempt by the district court. So that takes us back to liability and somewhat sanctions. So what happens if the board makes a decision on all this? Okay, well, where are the teeth? Well, the board is backed up by the court. If you are not following an order that is issued ultimately by the board on a complaint, then you can be held in civil contempt by the district court. So the district court still plays a role in all this. They just won't be the reviewing body and the adjudicating body anymore. That jurisdiction is going to revert back to the board. With all that being said, thank you very much, everyone, for joining us. And if you have any questions, you can reach me at my work cell, which is 651-259-1925, or at my email, and kclirlisle@flahertyhood.com. And one more note, actually, before I let you all go, if I see some numbers are fleeting away, so some of you will get this last tidbit of information, is take a look at your management rights provisions, and you might want to consider sprucing them up, because now would be the time than ever to show that something is expressly within your control and dominion, when otherwise it could be challenged as an unfair labor practice. All right, everyone, thank you very much for joining us, and have a great day.